Welcome to another episode of JurisQuestHub. I'm your host, Cynthia Liavule, a lawyer and advocate of the High Court of Kenya, a teacher at Hart, and a lover of philosophy of law. Before we get started, please consider subscribing to JurisQuestHub. Your support will enable us to continue providing valuable content on jurisprudence, the philosophy of law, and legal theory. Now let's get started on today's episode. In today's episode, the video will basically examine the Hart-Fuller debate through the lens of the Nazi-era legislation and will address a central problem in jurisprudence, that is, whether legal validity is separable from morality. By analyzing the two perspectives by the two renowned legal philosophers, that is H.L.A. Hart and Lon Fuller, the discussion will try to demonstrate why legal theory remains essential for understanding authority, legality, and justice in modern legal systems. Now, before we delve into all this, it's important to mention that at the core of many discussions in jurisprudence lies an examination of the different approaches to law advanced by individual legal theorists. And collectively, the outcome of this is commonly referred to as legal theory. So while legal theory plays a significant role in understanding the law, it is important to realize that jurisprudence is wider and more comprehensive and always encompasses legal theory as one of its key components. So for a start, just to have a quick overview of the term jurisprudence, it originates from the Latin words juris, meaning law, and prudentia, meaning knowledge or wisdom. And it is generally understood as the science or systematic study of the knowledge of law. Jurisprudence is concerned with the study of fundamental legal principles and seeks to explore their philosophical, historical, and sociological foundations. So it usually involves a critical analysis of core legal concepts, such as the nature and the purpose of law, legal rights, duties, possession, contracts, trusts, negligence, and even the concept of justice itself. So through this broad inquiry, jurisprudence aims to explain not only how the law operates, but also why it exists and how it ought to function in society. However, when we look at legal theory, it's basically a branch of jurisprudence, if we could call it that, because it specifically concentrates on the nature of law and its application, seeking to explain what qualifies as a law, a rule, a norm, a system, a practice, or as an institution of law. So basically what theories of law or what legal theory does is that it makes general and abstract claims about what law is, how you can identify what the law is, and the principles that distinguish legal rules from non-legal norms. So moving on, we'll now look at the limits and the value of legal theories. So from this, it's essential to examine the limitations of legal theories and also recognize that there's difficulty in simply developing a single comprehensive or sort of complete legal theory. And one of my favorite authors in jurisprudence is called Professor Brian Briggs. And in his book, Jurisprudence Theory and Context, he highlights the central challenges associated with theories of laws. So according to him, many disagreements within jurisprudence do not arise because one theory is entirely correct, while the others are entirely incorrect. Rather, his argument is that such disagreements occur because different legal theories are designed to answer different kinds of questions about law. So in his argument, firstly, he states that legal theories do not all pursue the same objectives. So some theories will focus on defining what law is, which is basically referred to as conceptual or descriptive theories. And then there are others which will explain how the law operates within society. And then there are other theories which will evaluate law from a moral or political perspective. So these theories, you could say, are guided by different aims, and the conflicts between them or among them are frequently misunderstood as direct contradictions. And his argument is that in reality, they basically reflect differences in emphasis and purposes rather than incompatibility. Another observation that Professor Bix makes is that legal theories often stem from evaluating them from standards that they were never intended to meet. So this is very evident, for example, later on when we shall look at the legal theories of natural law and legal positivism, which you could say legal positivism, for example, is criticized for failing to address moral questions, and then and when normative theories such as normal law focus on what law ought to be, they are faulted for not providing like value neutral descriptions of legal systems. So they sort of, his argument is that the theories or the critique of these theories overlook the distinct goals of their approaches. And then finally, which should be common sense for all of us, is that it's unrealistic to expect a single universal definition of law that can be applied across all societies and legal system. So from this, we can tell that law is inherently complex and tends to differ according to different social, cultural, historical contexts. And as a result, legal theories are often developed or are rather context dependent and necessarily incomplete. So you could say, for example, natural law and legal positivism, which we're going to elaborate in the coming videos, they successfully capture like important dimensions of the law. None of them is fully able to explain the phenomenon of law on its own. So each theory, you could say, has its own strengths and limitations. So in summary, despite the shortcomings and occasional conflicts, the diversity of legal theories remains very valuable because they help to clarify legal concepts, enhance legal reasoning, and encourage scholars and practitioners to think more critically and reflect about the law. So the problem of legal theories lies not in their adequacy, but in the mistaken belief that a single theory of law can provide all answers. So insofar as jurisprudence is concerned, for you and I, it's important to acknowledge the necessity of multiple theories so that you get a full understanding of the complex and multifaceted nature of law. So the challenges and limitations of legal theories are vividly illustrated in one of the most influential discussions in modern jurisprudence, and this is the debate between Lon Fuller and H.L.A. Hart. We've mentioned these two philosophers in our discussions before, and I think this is the juice of this video. So basically, their debate centers on a fundamental question in legal philosophy, that is whether law is inherently connected to morality or whether law and morality are conceptually distinct and should be treated separately. And what is exciting or very interesting about this discourse or this debate is that it took place in 1958 through a series of published articles in the Harvard Law Review, one of the leading academic journals in the United States. The debate was not a direct face-to-face confrontation or a tweet or the typical social media confrontation but rather a scholarly dialogue expressed through their respective writings. So Hart wrote an article which was titled Positivism and the Separation of Law and Morals. And a more detailed piece of the article will be in the description box, where Fuller responded with Positivism and Fidelity to Law, a reply to Professor Hart in the same journal. And what is key is that the historical context of this debate is crucial, because it was in the context of the post-World War II era, and the discussion was informed by the legal and moral failures of the Nazi Germany, which provided a real-world example for evaluating the relationship between law and morality. So let's look at Fuller's position. So what Fuller argued is that he criticized Hart's legal positivism. So later, when we discuss legal positivism and natural law, we'll understand that Lon Fuller was a proponent of natural law, and he was a proponent of what we call the internal morality of law, and he criticized positivism, legal positivism, by arguing that law necessarily embodies a moral dimension. So for him, the law or a legal system must adhere to certain procedural principles to function as law. Not everything can be termed as law. And these principles that the concept of law should have is that it should be clear, it should be consistent, there should be publicity, there should be prospectivity, and there's generality. And in the case of the Nazi era law, for Fuller, the systematic violation of this principle rendered a purported legal system deficient, because this undermined its claim to true legality. So for him, the law is not merely a set of commands, but a framework that respects human agency by allowing individuals to understand and follow rules. So consequently, for him, legality itself carries a moral character. For something to be termed as law, or for the concept of law, for the recognition of legality, something must carry moral character, because the law structures human behavior in accordance with fairness and rationality. Let's get to see what Hart's position was. So in contrast, Hart defended legal positivism, arguing that the validity of law depends on its sources within a legal system. So once a law is made by an existing authority, then it is valid, and it doesn't depend on its moral content. So according to Hart, a law is legally valid if it is created in accordance with accepted rules of recognition, irrespective of whether it is morally just or unjust. So he maintained a clear conceptual separation between law and morality, asserting that recognizing a law as legally valid does not equate to endorsing it morally. And he argued that such separation then allows legal scholars, I beg your pardon, and practitioners to analyze law systematically while retaining the ability to criticize unjust laws on moral grounds. So I hope we are together up to there. And as we can see, what Hart is basically saying, or rather his argument, is that for the Nazi era laws, even though they were morally abhorrent, they were still legally valid under German legal system, and the injustice that they caused should be condemned on moral grounds rather than being denied legal status. Fuller, on the other hand, counters that the Nazi enactments failed to meet the basic requirements of legality and therefore lacked true legal authority. So what is the key disagreement, or what is central to the disagreement between the two, Hart and Fuller, lies in their understanding of the relationship between law and morality. Fuller believes morality is internal to the concept of law, while Hart believes morality is external to legal validity. So from this debate, we basically see that there are two competing views of the law. Fuller emphasizes the moral foundations of legal order and the ethical conditions necessary for a law to function, while Hart emphasizes legal certainty, analytical clarity, and most importantly for him is the separation of law and morals. And from this, we can see that it really poses a great question, especially in the context where unjust laws exist. And the debate, we can see, remains relevant today. It remains central to jurisprudence because it shapes how scholars understand legal authority, justice, and the rule of law. Please share your thoughts on what you think of the Nazi law era. Were they really laws or not? So the Hart-Fuller debate clearly demonstrates why legal theory is an essential part of jurisprudence. Their disagreement shows that understanding law requires more than knowledge of legal rules. It requires theoretical analysis of the nature, the purpose, and moral foundations of law. First, the debate highlights how legal theory helps clarify what counts as law. So from it, we see Hart's positivist theory emphasizes legal validity based on social sources. So once an authority passes a law, for Hart, that becomes a law. But Fuller's theory stresses the moral and procedural conditions necessary for legality. So from this, we see that legal theory provides different frameworks for defining law, and this has implications. The implications are distinct. Second, the debate illustrates the role of legal theory in addressing the relationship between law and morality. Through their arguments, especially using the Nazi-era laws, Hart and Fuller demonstrate how theoretical perspectives shape responses to unjust laws. Legal theory therefore helps jurists critically evaluate whether obedience to the law should depend solely on legality or also on moral legitimacy. Thirdly, the debate underscores the practical importance of legal theory for judicial reasoning and legal reform. And we may not say it loudly, but judges, lawmakers, scholars, and legal practitioners rely on theoretical assumption, and most often implicitly, when interpreting laws or assessing their fairness. And the debate makes these assumptions quite explicit and open to scrutiny. And with that, we come to an end to this episode by concluding that legal theory is important because it provides us with the conceptual tools needed to understand legal validity, moral responsibility, and the rule of law. And this helps to move jurisprudence and understand it insofar as it goes beyond technical rules and engage with deeper principles that give law its authority and meaning. You're welcome to in-depth reading of texts used for this episode provided in the description text. If you enjoyed this episode, don't forget to like, subscribe, and ring the bell. You won't want to miss the next one. Happy holidays, a happy Christmas season, and good tidings for the new year.